CRPC. I'm going to share the screen with all of you. One of the most important subject, and when we CRPC, it's right on your screen. Everybody can have a look. Okay, so we're going to start with CRPC here. Now, the first and the foremost thing we need to understand when we speak of CRPC here is that CRPC is a consolidating and an amending law. So this is a question that is normally asked in the paper, that what kind of a law is CRPC? So CRPC is your consolidating and your amending law. If you come to the applicability of CRPC, the applicability is very simple. This particular law, it applies to the whole of India, including the states of Jammu and Kashmir. Now, earlier, this particular provision, it was not available to the state of Jammu and Kashmir. So CRPC was not applicable. Okay, am I audible? So let's just, please allow me a minute. Okay. So dear students, am I audible? And is the screen visible to all of you? Okay. So let's just start again, okay? So I'm so sorry for the technical difficulty. So now we're going to start with, I'll again start with all of you. So we're going to deal with CRPC. Okay. So this is a rapid revision that we're going to deal with. And I'm just going to quickly move on to the first provision here. So when we see the first provision here, so we can see on the whiteboard here that when we speak of CRPC, the most important procedural laws. Now, the entire criminal justice system that we have, this revolves around CRPC. And this also makes CRPC one of the most important, especially your prelims. You can expect direct questions from your CRPC, which are going to be at least 15 to 20. Okay, so let's just start. Now, when we speak of CRPC, the first thing we have to understand here is that this is a consolidating and so the first question that is normally asked in the paper is that what kind of an act is CRPC? Is in consolidating that this particular law, bacha, this is applicable to the entire India, that is the whole of India. Earlier, this was not applicable to the whole of India. That means it was not applicable on, the states of Jammu and Kashmir. But as of now, this particular law is applicable to the entire India. Another date which is very important for your exams is 1st April 1974. Now, in 1st April 1974, this particular law, that is CRPC, it came into force. Now, Section 2, it deals with your definition.
Okay. So am I audible now? Okay. So I am just going to quickly share the screen with all of you. Okay. So is it fine now? Okay. So let's just start now. So I was telling you, I told you about the first division, and now just move on to section 2. Because section 2 is very important. This is your definitive clause, and this is very important. So the first thing you need to understand here is section 2A, which is dealing with your bailable offense. So bailable offense, here you have to take care of. It is either going to be the first rule or any other rule. Both the things are included. Please put a tick on section 2A. This is your prelims question. Section 2B talks about charge, that what is a charge. Now a charge here means a head of charge. Charge contains more than one head. So you can have 2 or 3 charges also in one particular offense here. Now when we come to section 2.6, this is a very important question for your prelims. It talks about a cognizable offense. That what is a cognizable offense? Now, in cognizable offense, here, please have a look, everybody, that a police officer, the word used is may. The police officer may arrest without warrant. It is not shall, it is may. Please underline may. It's may. When we come to section 2D, 2D is very important. It talks about complaint. That what is complaint here? But that complaint is an allegation. This allegation can be oral or it can be in writing also. And this allegation is made to whom? It is made to a magistrate, underlying magistrate, with a purpose. And that purpose is that either a person known or an unknown person also. So in complaint, the person can be known, he can be unknown also. But a complaint does not include a police report. So if you have to underline this also, this is very important that a complaint does not include a police complaint here. Now, moving on, if you come to the explanation here, the explanation makes it very clear that once, after investigation, we get to know that it is a non-cognizable offense. Now, it's going to be deemed as a complaint. So the word uses shall. So this shall be a complaint, and the report that has been made by the police officer here, he will be deemed to be a complainant. So who will be deemed to be a complainant? The police officer shall be made, deemed to be a complainant. On this regard, please come forward and come to 2G. 2G talks about inquiry. Now, inquiry is other than a trial. This is not a trial. It is other than a trial. And who conducts a inquiry? It can either be a magistrate or it can be a court also. When we speak of investigation to H, now in what is investigation? Investigation is collection of evidence which is done by the police officer or any other person. So, investigation is one area which is always done by the police officer, and the purpose of your investigation here is to collect the evidence which is conducted by the police officer. When you speak of judicial proceeding, Bajaj, judicial proceeding is always taken on oath. Always remember that judicial proceeding is on oath. Now, moving on, what is a local jurisdiction? 2J deals with local jurisdiction. Now, local jurisdiction here, it means it's a local area. Which local area we're talking about? Local area where a particular court or any magistrate is going to exercise his powers. Okay. Now, metropolitan area is 2K. Now, metropolitan area is an area which is declared under Section 8, underline Section 8 to be a metropolitan area. Section 2L, this definition is very important, but that what is a non-cognizable offense? A non-cognizable offense is an offense where the police officer has no authority to arrest without warrant. Like we told you that in cognizable offense, a police officer can arrest without warrant. Here, in non-cognizable, the police officer does not have the authority to arrest without warrant. Speaking of Section 2N, this is very important. What is offense? Now, offense, it can be any act, it can be any omission which is punishable by law. Now, this is very important. And in this regard, please underline it can be a complaint under Section 20 of the Cattle Trespass Act of 1871 also. So, in offense, when we speak of in, it can be an act or plus it can be Section 20 of the Cattle Trespassers Act. Now, at times in exams, you are also asked about where do you find police report? Now, 2R. R stands for report, R stands for police report. So, 2R deals with police report. So, where is police report defined? It is defined in 2R. What is a police report? A police report is a report which is forwarded by a police officer to a magistrate. And the section has been mentioned. It is 173 subsection 2. Now, at times they offer, they ask you who is a public prosecutor, which section defines. 2U defines public prosecutor. What is a summon case? Summon case is very important for your prelims. Summon case is a case which is not a warrant case. And then you have the definition of victim. Victim is very important, often asked in your prelims. Now, who is a victim? Victim is a person who has suffered any loss or injury. But the question that is asked in your paper is that victim includes whom? The victim is going to include your guardian or your legal heir. Please underline, this is very important. So, victim includes your guardian or legal heir. Now, warrant cases. What are warrant cases? Favorite question for prelims. What are warrant cases? Warrant cases are those cases where the punishment is death, imprisonment for life, or a term exceeding 2 years. This is very important. Underline exceeding 2 years. Now, if you come to the last definition, it makes it very clear that if there is a word or an expression which is not defined here, now the definition here will be looked into IPC. If you have any particular word or expression which is not defined in CRPC, but it is defined in IPC, you are going to look for the meaning which is given in IPC. On this note, all of you, please come to section 4. Now, section 4 is very important question for your prelims. Now, in section 4, what is this particular section dealing with? Section 4 is telling you that this is very interesting, all of you. Section 4, subsection 1, it is saying offenses under IPC. They are shall be investigated, inquired, and tried under CRPC. So, section 4, subsection 1 is dealing with IPC. Section 4, subsection 2 is not dealing with IPC, it is dealing with any other law. This is a very important provision, everybody. Section 4, subsection 1, it talks about IPC, that it has to be investigated, inquired, and tried under CRPC. Section 4, subsection 2 is dealing with any other law. Now, moving on to chapter 2. Now, chapter 2 is a very important chapter, and here, please understand, you are going to get a question from chapter 2. This is one chapter from where you can expect a question. Now, what is chapter 2 talking about? Let's talk about the classes of criminal courts. So, under section 6, if you leave the High Court, how many courts are there? Very important question. You have 4 categories of courts. One is Court of Session, then you have Court of JMIC, and of course, Metropolitan Magistrates are also there. And at the same time, you have judicial magistrates second class, and then you have executive magistrates. So, how many categories are there? There are four categories. Please have a look, everybody. Session Court, JMIC, Metropolitan in one go. You have JMI, Judicial Magistrate second class, and then you have Executive Magistrate. So, in total, you have four courts that are dealing under Section 6. Now, Section 7, it is telling you how are you going to divide the territorial division. So in CRPC, the territorial division is divided into session division, Bacha, and this is done by the state. Always remember that it is the state who's going to do it. Now, if you have to alter the limits of the subdivisions or any kind of district, this has to be done by the state government after consultation with the High Court. Please underline, this is may. I mean, it's not necessary. The word used is may, not shall. The state government may, after consultation with the High Court, again, your prelims question here, whether it is may or shall, this is may. Now, again, you come to section 8 here. In section 8, the question is who's going to declare any particular area as a metropolitan area? Always remember, this is the state government who's going to declare any area as a metropolitan area, and the population is given which exceeds 1 million here. Okay, so if you come to this, please come to section 8, subsection 4. All of you, subsection 4. This is very important, that if there is any area which has been declared or deemed to be declared as a metropolitan area and the population falls below 1 million, now what is going to happen? The state government may by notification. Again, prelims question, everybody. Whether the word is shall or may, it is may. Who's going to declare it? The state government is going to declare that this particular area is not going to be a metropolitan area. So under section 8, we have three prelims questions. First part, who's going to declare a particular area as a metropolitan area? It is the state government. What is the criteria? 1 million. If the population falls below 1 million, who's going to declare it or who say that it is going to cease to be a metropolitan area? It is again the state government by notification. The word used is may. Please come to section 9, all of you. Section 9, again, direct question for your prelims. It is talking about three categories here. The first category is that who establishes the court of sessions. But the court is established by the state government. State government is going to establish the court of session. But the appointment is made by the judge who is going to be appointed by the High Court. So the Court of Sessions is established by the state government, but under Section 9, the judges are appointed by the High Court. Under Section 9, one very important point that we tend to skip here is that is Section 9, subsection 6, which says that can the Court of Session hold its sitting at some other place? The answer is yes. Section 9, subsection 6 is giving you this provision. It says that the court of session shall ordinarily hold the sitting at the place where the High Court is staying. But if there is a particular place and the court of session is of the opinion that it is of general convenience of the parties and the witnesses, and it has to be with the consent of the prosecution and the accuser, but they can sit at some other place also. So section 9 basically talks about three very important questions. One is who's going to establish the court of sessions? That is the state government. It is presided over a judge that is appointed by the High Court, and at the same time, the court of session can also hold its meeting at some other place which is of general convenience, but it has to be with the consent of the prosecution and the accused. If we come to the explanation given to section 9, it says the appointment does not include the first appointment. Now, please underline this. This is trying to tell you that we are not talking about the first appointment. The first appointment is always made by the governor under Article 230. So you can write it down. Article 233, the governor is going to make the first appointment. Now we move on. Everybody come to section 10. Now section 10 is talking about the subordination. The subordination of whom? Of the assistant session judges. Always remember the word used under section 10 is assistant session judge. We are not talking about additional session judge. So additional session judge, they are at par with the session judges. It is the assistant session judge who is subordinate to the session judge. Okay. Now, under section 11, we are talking about the Code of Judicial Magistrate. This is a very important question to all of you, that which section deals with the Code of Judicial Magistrates. This is section 11. Now, in section 11, all of you, please remember that the presiding officers are always appointed by the High Court. So, your appointment will be done by the High Court. Okay, so under section 11, it deals with, this is a section based question. Which section deals with the courts of judicial magistrates? This is section 11. Who appoints the presiding officer of these particular courts? They are the High Court appoints them. Now, section 12 talks about CGM, and please remember that again, out of all the JMICs that are available, the High Court is going to appoint one of the judicial magistrate as CGM. Section 13 is very important for your exams. Now, in section 13, we are dealing with the special judicial magistrates. Now, these special judicial magistrates, please all of you open your bare and keep your highlighters ready. Underline, it is the High Court may. The High Court may, if they are requested by the central or the state government here. So, either the center or the state government, they are going to request the High Court that please appoint somebody as a special judicial magistrate. Now, these special judicial magistrates, this is a very important question for your prelims. They are going to be appointed for a term not exceeding 1 year at a time. So, special judicial magistrates are appointed by whom? By the High Court. They are requested by the central or the state government here. The term that has been given is 1 year. So, they cannot exceed a term which is 1 year. Now, section 14 is your local jurisdiction of judicial magistrates, that every, the CGM is going to decide the local jurisdiction here of every judicial magistrate. Now, moving on to subordination. Now, but this goes in a particular, this is like a timeline which is going here. First, you have jurisdiction, then you have subordination, and when you come to subordination, everybody, please have a look that every CGM shall be subordinate to the session judge, and every judicial magistrate subject to the general control. So the general control will be of the session judge, but every judicial magistrate is going to be subordinate to the CGM here. So till section 15, you have judicial magistrates, then you have the court of metropolitan magistrates. We know metropolitan magistrates are dealt under 8. Again, the deciding officers are appointed by the High Court. Under section 17, we are talking about the chief metropolitan magistrate or additional chief metropolitan magistrate. In this regard, section 18 is very important. 18 deals with the special metropolitan magistrates. Now again, the provision remains the same. It is the High Court may, if requested by the central or the state government. Again, it's going to be the High Court if requested by the central or the state government. Here, they are going to appoint special metropolitan magistrates. Bacha, under subsection 2, again your prelims question, not exceeding 1 year at a time. The special metropolitan magistrates, they are appointed for a term not exceeding 1 year. Now, if you analyze section 18 carefully, under section 18, all of you please have a look. Under section 30, we read that it was the High Court that is going to empower, a special judicial magistrate to exercise the powers. But in section 18, The word is the High Court or the state government. So when you speak of special metropolitan magistrates, it can either be the High Court or the state government that is going to empower any special metropolitan magistrate here to exercise, their power outside the metropolitan area, and these powers are going to be powers of the. Then you have the subordination. The subordination remains the same. They are subordinate to the session judge, and the general control is going to be of the session judge. But the other metropolitan magistrates, they are always subordinate to the chief metropolitan magistrate. Please understand here that the general control will always be of the session judge, but when you speak of the subordination, here they are going to be subordinate to the chief metropolitan magistrate. Now, section 20 talks about your executive magistrate. Now, speaking of executive magistrate here, section 20 is very important, and it is telling you that in every district and in every metropolitan area, the state government is going to appoint as many persons. There is no limit, can be as many persons, and they are going to be named as executive magistrate. And out of those executive magistrates, one of them will be a DM. Like we studied in the judicial magistrate, one of them is going to be a CGM. Here, one of the executive magistrate is going to be the DM here. Now, if you come to section 21, this is very important for your prelims. Section 21 talks about special executive magistrates. Now, this is a point of difference here. In special judicial magistrates, special metropolitan magistrates, it was the High Court. But when you come to the special executive magistrate, it is the state government. It is not the High Court, it is the state government. And in section 21, we do not have a timeline which has been mentioned. Like you have a time period given under section 13 and 18, this time period is not there in section 21. Then we come to section 24. Section 24 is again a very important section for your prelims. Direct question is asked. Now, public prosecutor. Which section? First, you have to understand that where is public prosecutor defined? Public prosecutor was defined under section 2U, U for umbrella. And where do you have public prosecutors here? Very important question. Now, for every high court, the central government or the state government shall, after consultation with the High Court, that means for the High Courts, the central or the state government is going to appoint the PP, but this is going to be shall after the consultation with the High Court. That is underlined, shall after consultation. Till now, we have studied the word may. Now, section 24 uses the word shall. So, for TP, the consultation of the High Court is mandatory here. If you come to subsection 4 here, who's going to prepare a panel of person who can be appointed as TP? It is going to be the DM consultation with the session judge. Very important question for the. So the DM in consultation with the session judge is going to appoint a PP or an additional PP. Now, all of you come to subsection 6. In subsection 6, we are saying if in a state there is already a regular cadre of prosecuting officers, that means if you have a regular cadre and a prosecuting officer is available, now the state government is going to appoint a PP or additional PP from that particular cadre only. If there is a cadre existing, you are going to appoint a person as PP from that particular cadre. Now, if you want to be appointed as a PP or an additional PP, subsection 7 tells you that you need to have a practice as an advocate for not less than 7 years. Very important question for your prelims. Then again, if you need a special PP, this is important. Special PP says the time period has to be 10 years. So you need to practice as in special PP for 10 years. So if you want to be appointed as PP, here the advocate should be in practice for not less than 7 years. But if you're speaking of, special people here, it is going to be 10 years. Now, all of you on this point, please come to the next section here, which is very, very, very important, which is assistant. Now, when we speak of assistant PPs, the state government is going to appoint under Section 25. Where are you going to appoint? We are going to be appointed in a district area. In which courts? Very important question for prelims. In courts of magistrates. So assistant PPs are always appointed in the courts of magistrates. Who appoints them? The state government appoints them. Very, very, very important question. And subsection 2 makes it very clear that no police officer can be appointed as a PP. So, this is a very important point here that assistant PPs are always appointed by the state government. Where are they appointed? They are appointed in the courts of magistrate. Can a public officer, a police officer be appointed as assistant PP? The answer is no. In this regard, section 3 is very important. Section 3 says, let's say that if there is a particular case, and in this particular case, assistant PP is not available. Okay. Now, what are you going to do? DM here is going to appoint any other person as PP. But this proviso is the one where you get the question from. This police officer shall not be appointed if he has taken part in the investigation. So, subsection 2 is telling you that the police officer shall never be appointed as a PP, that is assistant PP. But subsection 3 is going to be the proviso to subsection 2, and it says that if assistant PP is not available for a particular case, now what is he going to do? He can appoint a police officer. But in this particular case, the police officer will not be appointed if he has taken part in the investigation or if below the rank of inspector. The word used or it is not and. That means either of the two. Please remember this particular proviso, very important. At times, direct question is asked from this particular area only. Okay, now moving on, let's come to the Directorate of Prosecution. The question that is asked from this area is which section deals with the Directorate of the Prosecution? It is section 25A. And who is going to establish this Directorate of Prosecution? It is the state government who is going to establish. So under section 25A, what is important for all of you? Who establishes? The state government is going to establish. Which section deals with it? It is section 25A that deals with the Directorate of Prosecution here. And this particular provision was not there originally in our CRPC. It was added by the 2005 amendment. Please write it down, 2005 amendment. Now, if you come to the section 25A and you come to the third subsection, it says the head of the Directorate of Prosecution shall be the director. We're going to have a director of prosecution and he's going to be under the administrative control of whom? It is going to be the home department in the state. Very important question. Please underline. This is your home department in the state. So this director of prosecution is going to be working under the direct home department in the state. This question has been asked multiple times in your prelims. Very important question, section 25A. Now, another question which is relevant under section 25A is, will the provision of section 25A applicable to an advocate general? The answer is no. Section 25A, section A makes it very clear it shall not apply to the AG of a state. So please remember that in section 25A 2005 amendment, state government is going to establish your directorate of your prosecution. This are going to be under the home department. The provisions will not apply to the state. Now, till this point, are we clear, everybody? Everybody, please. Are we clear? Anybody with a doubt on this particular point? No one? Okay. Then moving on, we are going to talk about chapter 3 now. We moved to chapter 3. Now, chapter 3 is very important, and there are only few provisions that need to be understood here. The first particular section is section 26. Now, section 26 is telling you better that let's say there is an offense which has been committed under IPC, who is going to try it. Either the High Court is going to try it, or the Court of Session is going to try it, or any other court which is shown in the first schedule. So please remember, under section 26, we have High Court, Court of Session, or any other court which is given in the first schedule. But at the same time, if there is an offense which is tribal, that is section 376 A, B, B, C, A, D, B, relating for the rape provisions here, they shall be tried as practically possible by a woman. So here the women is going to be a part. So under section 26, have that any offence given under IPC is going to be tried by High Court or Court of Session or any other which is given in the first schedule. But please remember, there the rape provisions are there. In the rape provision, they are going to be presided over by a woman. Now, section 27 is a very important section and it talks about the juvenile court. Now, in section 27, when you speak of the jurisdiction of the case of juveniles here, if there is an offense which is not punishable with death or imprisonment for life, it should not be punishable with death or imprisonment for life. And when brought before the court, Bacha, the age is 16 years. So he is under the age of 16 years. Now what is going to happen? He is going to be tried by a court of CGM here or any other court which is empowered under the Children's Act 1960. Please underline, in this particular section, 27, section-based questions are important. Which section deals with 27? The offences should not be death or life imprisonment, 16 years, and they're going to be tried by a court of CGM or any other court which is empowered under the Children's Act of 1960. Now, section 20, this is very important because it talks about the sentences that the High Court and the session judge can pass. Please remember that the High Court can pass any sentence. There is no limitation on the sentence that can be passed by the High Court. But when you speak of a session judge or an additional session judge, they can pass any sentence authorized by law. But let's suppose a death sentence has to be passed, it is passed by this particular judge, it is going to be shall be subject to the confirmation of the High Court. It is not may, it is shall be subject to the confirmation of the High Court. So here, the High Court is going to confirm this particular point. And in this regard, we have other provisions of CRPC also that are dealing with the confirmation of death sentence by the High Court. If you speak of the assistant session judge, the assistant session judge can pass any sentence except a sentence of death or imprisonment for life or an imprisonment exceeding 10 years. In other words, assistant session judge can pass a sentence not exceeding 10 years. So this also means that the additional session judge and assistant session judge, they are different. And assistant session judge is subordinate to the additional session judge because even their punishment is different. Now you come to the section which is relevant to most of you. That is the sentence the magistrates can pass. Very important question. Section 29 is dealing with the sentences that you people can pass. So if you speak of CGM, the CGM can pass any sentence here which should not be exceeding 7 years. So it should not be death, it should not be life, it should not be exceeding 7 years. But when you speak of a court of the first class, now the magistrate first class can pass imprisonment not exceeding 3 years. The word used is not. It is not less than 3 years or any other word. It is not exceeding 3 years. So you cannot pass a sentence which is remember, it is not exceeding 3 years. This question has been asked many times in your. It is not exceeding 3 years, or a fine not exceeding 10,000, or both. Now, when you speak of second class, the court of magistrate of second class, he cannot pass an imprisonment not exceeding 1 year again, and the fine is not exceeding 5,000, or both. Direct question for your prelims. Please remember, CGM cannot pass a term exceeding 7 years, JMIC not exceeding 3 years, or a fine not exceeding 10,000, or both. And when you speak of subsection 3, judicial magistrate second class cannot pass an imprisonment not exceeding 1 year, or a fine not exceeding 5,000, or both. I am emphasizing on the word not, because this is your direct question. Friends, it is not any other thing. The word used is not. Please remember. Now we come to section 30. Now, section 30 talks about sentence of imprisonment in default of fine. Now, what is going to be the situation if there is a court of magistrate who award you a term of imprisonment and there is default of payment of fine? So, in this particular case, what is going to happen? Now, the JMIC here, he cannot give you any other, imprisonment which is exceeding his powers. So that means he cannot give you the imprisonment exceeding 3 years. And shall not, the word is shall not. If imprisonment has been awarded as a part of your substantive sentence, 1/4 of the term of imprisonment which the magistrate is competent to inflict otherwise than in default of. So please remember section 30 here, what is going to happen in this particular case, that the magistrate in default of fine, it cannot be in excess of the powers given on the magistrate, number one, and number two here, shall not, if the punishment is a part of your substantive sentence, 1/4, very important question for your prelims, 1/4 of the term of imprisonment, Bajaj, cannot be exceeded here. And if you come to subsection 2, this is very important. Now the imprisonment that will be awarded in part of the payment of the fine, this is going to be in addition to the substantive sentence of imprisonment awarded for the maximum term awardable by the magistrate section 29. Let me explain you this point with an example. Let's suppose the magistrate has awarded, the JMIC here has awarded a punishment of 2 years. Okay, let's say 4 months extra have been given to somebody who has 4 months is because of the default in the payment of fine. Now the total punishment is not going to be 2 years; it's going to be 2 years plus 4 months. So this imprisonment is going to be in addition. In addition is your direct prelims question here. It is in addition to the punishment which is awarded by the magistrate as part of your substantive sentence. If you come to section 31, now section 31 is throwing a lot of information at you, and it is basically saying that what is going to be the situation that if you are, there's one trial going on, and a person accused, he is convicted of several offences. What are you going to do? Now, please remember, under section 31 of CPC, each punishment is going to commence one after the other. Let's suppose the punishment awarded is, let's say, 1 year, then 3 years. So one trial, one offense, the case is awarded 1 year. So the other offense is 2 years, and then it is 3 years. Now, the general rule is going to commence one after the other. That means it's going to commence consecutively. So for 1 year, then 2 years, then 3 years. Or now comes the important point here. Until and unless the court orders that these punishments shall run concurrently. So, for example, if somebody is awarded let's say 1 plus 2 plus 3. So here the total is 6 years, correct? Now we cannot say that the general rules is consecutively, one after the other. Let's say he's been awarded 3 plus 3 plus 7. Let's say 11 years of imprisonment. General rule is it's going to be one after the other. But the court may order that it can run concurrent, that is side by side, hand in hand. Please remember that under Section 31, general rule is it is going to run consecutively, but special rule is only when the court directs that it can run job concurrently, only when it's going to run concurrently. Otherwise, it is not going to run concurrently here. On this point, all of you come to section 32. 32 talks about mode of conferring the power. Who confers the power under CRPC? It is going to be the High Court or the State Government. Very important question for your parents. That who confers the power, High Court or the State Government? And at the same time, Section 34 is talking about the withdrawal of power. Who can withdraw the power? Who can withdraw the power? It is again going to be the High Court or the State Government here. High Court or the State Government. So the court which is under CRPC, the power is being conferred by the High Court or by the State Government, and at the same time it can be withdrawn by whom? By the High Court or by the State Government here. Okay, so on this point, let me ask you people one thing. Is everything okay? Am I audible? Is the screen visible? Vishesh, voice is lagging. Screen is blurred. Okay, one second, let me see. Vishesh, is it fine now? Yes. Is the screen still lagging? One of you please tell me. Okay. Is it fine now? Vishesh, is it fine? Okay. Now let's just proceed. We come to chapter 4 here, and chapter 4, this is something which you can, there's only a reading which is required in chapter 4. In chapter 4, you have to read section 30, section 37. 36 talks about the powers of the superior courts officers of the police, and 37 is a very important question for your prelims. Public went to assist the magistrates and the police. So under section 37, Bacha, it says that every person is bound to assist a magistrate or a police officer. So section 37 is dealing with your every person here is bound to assist the magistrate. So section 37 is a specific section where public is to assist the magistrate and the police. In section 38, it's different. It is talking about aiding to a person other than a police officer executing a warrant. Now, if let's say a warrant is directed to a person who's not a police officer, now any other person, he may aid in execution of such warrant. So, and in section 37, public is bound to assist a magistrate. Section 37. 38, if your arrest warrant is directed to any other person other than a police officer, then section 38 comes into picture. You have to aid that any other person. Section 39, beta, this requires a quick reading from all of you. Here we are talking about when the public is required to give information to certain offenses. So these offenses, and every person here, you know that any person has intention also to commit these offenses, you can and you should inform inform the police here, and this is a specific section. You can just give it a reading. Write down reading required in section 39. But section 37 and 38 are very important for your prelims. In 37, you are public is assisting the magistrate, and in 38, you are aiding if any other person is executing a warrant here. Now, we come to chapter 5, the most important chapter here, and chapter 5 deals with the arrest of person. Very, very, very important. You can expect 2 to 3 questions from this chapter itself. So when we speak of chapter 5, the chapter itself is important. The number is important. It is chapter 5. We are dealing with arrest. The first section is section 41. Section 41 is talking about a police officer. When can he arrest without a warrant? So if you look at your screen, everybody, any police officer may without an order and without a warrant. Both the things are included in section 41. May without an order from the magistrate. So if the magistrate has not ordered, without that also, and without a warrant also. Please remember, both the things are included. Direct question for your opponent. Very, very, very important here. It has to be, can be without an order from the magistrate. It can be without a warrant also. Now, we come to section 41, and what is it dealing with? It is dealing with something very interesting, and it is saying that a police officer may without an order, may without a warrant also, he can arrest a person who in his presence, if he has committed a cognizable offense, he can be arrested. Again, if you come to subsection B, you have RCR. So this is the acronym. R, reasonable complaint. C, credible information. Then R again, reasonable suspicion. So the acronym here is RCR. Reasonable complaint, you have received credible information, or there is a reasonable suspicion also. What is it? That a person has committed a cognizable offense which may be punished less than 7 years, or which may extend to 7 years without fine if there are certain conditions that are being fulfilled. So section 41 here, the most important point that we understand here is that when can the police officer arrest without warrant? It is may without an order. This is without a warrant also, without an order also. If in the presence of the police officer you've committed a cognizable offense, or RCR has been received. Now, if you look at clause 2 to section B, it is dealing with certain pointers. These pointers are also very important. I'm going to quickly read it for all of you. Please tick these points. So when we speak of the first point, here the police officer has a reason to believe. The first point is that you have a reason to believe, and what is this reason? That some information has that person has committed the offense. Then, to prevent such person from committing any further offense, so proper investigation, or it can be, avoid the tampering of the evidence, or it can be to avoid this person to make any inducement, threat, or promise, or it can be anything here. Now, the police officer shall record while making an arrest reasons in writing. So the reasons have to be recorded by the police officer in writing if he is making an arrest. This comes with a proviso again. The proviso says, provided that the police officer shall, in all cases where the arrest of the person is not required under the provision of this section, record the reasons in writing for not making the arrest. Okay, so this is a very important point. Then you have section BA here, section 41, clause BA, which is talking about the fact that the credible information has been received that this particular person has committed a cognizable offense where the imprisonment would be exceeding 7 years, it can be with or without fine, it can be death. Then you are a proclaimed offender here. Then in the possession of a person, you found stolen property. Then you are obstructing, the person is obstructing a police officer while he is in execution of a duty. These pointers are important, you can expect a question from these pointers. So then, reasonably suspected of being deserted of the armed forces of the Union is a very important point here. Because this question has been asked multiple times in your paper, that can the police officer arrest a deserter of the armed forces of the Union without warrant? The answer is yes. He can be arrested under Section 41. Then you've received a reasonable complaint has been received. Again, this is RCR, credible information you've received, or there's a reasonable suspicion that this person has committed an act which is out of India. Very important point. This is out of India. Then you are a released convict where you have made a breach of rule. Again, you can be arrested without warrant. Now, if you look at subsection 2 says, subject to the provision of section 42, no person concerned here, no person concerned in a non-cognizable offense or against whom a complaint or has been made or a credible information has been received, he cannot be arrested without a warrant. So that means in non-cognizable offenses, you cannot arrest a person without a warrant, and this has been given under section 41, subsection 2. A very important section for your exam. Direct question is expected. Now we come to section 41, A, B, C, D. But the A, B, C, D, these provisions were not given originally in CRPC. They were added by the 2009 amendment. Please remember 2009 amendment is very, very important. Please underline that this was added by the 2009 amendment. So here, this is basically in consonance with the criminal justice system, and this is like with the powers of the police officers. Now, in NCPR, I'm going to find an acronym for all of you. It is notice. 41A talks about notice. The sections are very important. Notice, 41B talks about the procedure, and then 41C talks about control rooms, and D talks about the rights of arrested persons here. It is known as NPCR. Okay, so let's talk about the notice here. Now, the notice says the police 41A, very important. Notice the police officer shall, in all cases where the arrest is not required here, now he is going to issue a notice. Let's say under section 41, subsection 1, the arrest is not required. Now he is going to issue a notice to a person against RCR has been received here. The word shall, that means it is mandatory to issue a notice. Then, if the notice is issued, it shall be the duty of the person to comply with the terms of the notice. Then, what is going to happen? If the person complies with the terms of the notice, he shall not be arrested. Please remember, this is the question that if a person against whom the notice has been issued, if he complies with the notice, can he be arrested? No, he shall not be arrested. Now, section 41A, clause 4 says, where such person at any time fails to comply with the terms of the notice or he doesn't identify it, now the police officer may. Now he may do what? He may arrest. 41A, very important. A notice has to be issued if arrest cannot be made under section 41, subsection 1 here. Then what is going to be the procedure? The procedure again is very simple. The word used is shall. Number one, you have to wear, the police officer has to wear a accurate, visible, clear identification of his name. So the person to be arrested here, he should know that he is going to be arrested and your name should be accurate, visible, and clear. This is a very important question that we're about to do. Prelims question. You are going to prepare, the police officer is going to prepare a memorandum of arrest. Who's going to attest it? Now, it has to be attested by at least one witness. Who can be this one person? This witness can be the member of the family of the person you're going to arrest or any respectable member of the locality here where the arrest is Remember, this memo has to be attested by one person. It can be anybody here, and then it has to be countersigned also by the person arrested. This is very important. The person arrested countersign that. Then inform the person arrested unless the memorandum is attested by a member of the family that he has a right to have a relative or a friend to be informed of his arrest. His arrest has to be informed to his members of the family here. 41C, that the state government establish the control rooms here. Very important. Who's going to establish the control rooms? The central government, the state government. Where are they going to establish? The district level or the state level. 41C is talking about the control room. So C for control, C for the provision. 41C. 41D are very important. That rights of arrested person to meet an advocate of his choice during interrogation. Now it says when any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation. Yes, you can meet your advocate of choice during interrogation, but though not throughout interrogation. Direct question for your present. It has been asked multiple times. In Section D, an arrested person has a right to meet an advocate. Sorry, this has been a technical glitch. 1 second, all of you. I'm just going to take you back 1 second, all of you. So, yeah, we'll go back. We were on section 42. I'm just going to quickly take you to section 42. 1 second. Okay, so please tell me, is the screen visible? All of you, is the screen visible? Okay, so we come to section 42. So we were on section 42. Please give me a heads up that if everything is absolutely fine. Am I audible? Is the screen visible? Are you able to see everything on the screen? Okay. So we were talking about section 42. Now I told you that in section 42 here, if the person arrested, bacha, if his true name and residence, it can be ascertained here. Now he shall be released. He's going to be released on executing a bond here. Okay, so he is going to be released executing a bond with or without surety. It can be either with or without surety here. Now, on this point, provided that if such person is not a resident in India, then this person, the bond here has to be secured by a surety who is a resident in India. And let's say the true name cannot be ascertained within 24 hours here. Now he is going to be forwarded to the nearest magistrate having jurisdiction. Please understand that here under section 42, you will be, the accused here will be forwarded to the nearest magistrate having jurisdiction. So it's going to be section 42 subsection 3. We are talking about shall be forwarded to the nearest magistrate here. We come to section 43, but the section 43 is very important, and section 43 is a direct question for your prelims. It says, when can a private person arrest a person? Now a private person can also arrest. The word used is may arrest or cause to be arrested. Now when in his presence, now underline, somebody commits a non bailable and a cognizable offense. Please underline this. This is a very important question. Somebody has committed a non bailable and a cognizable offense, or he's a proclaimed offender. So either it's going to be non-bailable and cognizable. It is not or cognizable, it is and cognizable. And any proclaimed offender here can, he has committed a non-bailable and a cognizable offense. Now this private person can arrest this particular person here. Now what is going to happen here in this particular section, section 43 subsection 2 is also telling you if there is a reason to believe that such person comes under the provisions of section 41. Now if you know that here section 41 is going to be applicable, the police officer shall re-arrest him. Again, a very important question, shall re-arrest him here. So section 43 is very important for your exams. All of you, please remember that under section 43, what is going to happen? In section 43, here we are referring to arrest made by a private person. Now we come to section 44. 44 talks about arrest by a magistrate. Now direct question for your prelims. When can an arrest be made by a magistrate? It is going to be section 44. When in his presence, whether you are a executive magistrate or a judicial magistrate, some kind of an offense has been committed. So section 44 talks about arrest by magistrate. Section 45 is talking about the protection of the members of the armed forces from arrest here. Now, what is happening in section 45? It says no member of the armed forces of the union here shall be arrested for anything done or reputed to be done in the discharge of his official duty only after obtaining the consent of the central government. So if you want to arrest an armed forces, a member of the armed forces of the union, for whatever he's done in the discharge of his official duty, you need to obtain the consent of the central government. The subsection 2 here is talking about the same provision dealing with the state government here. Okay, but here please remember that, let's say there is a person who has, okay, am I audible? Let's say if there is a person, bacha, who basically he's a member of the armed forces and he is basically, he has escaped here. Okay, on this particular person, section 45 is not going to be applicable. Now section 46 is talking about the procedure of how you're going to make the arrest here. Now let's see how are you going to make the arrest. Section 46 says how is the arrest going to be made. So the first point here is that you have to actually touch or confine the person to be arrested until and unless there is an oral submission. For example, let's say if you want to arrest X here and there is no actual submission, now you can touch the person here. But if there is a woman who has to be arrested, now please remember, oral intimation of arrest shall be presumed. The word is shall, please underline, shall be presumed. And if you have to arrest a woman here, she has to be arrested by a police officer who's also going to be a female. Then if such person forcibly resists to endeavor to arrest him, now the police here can use all means. So you can use all means to effect the arrest, but in that particular case, you cannot cause the death of the person who is not accused of an offense punishable with death or imprisonment for life here. Then here, subsection 4 here is telling you that if you want to arrest a woman here, you can only arrest the women if this is after sunset and before sunrise. Now the procedure is very important. You need to make a written report. This written report plus the prior permission of the JMIC has to be taken. Which JMIC, in whose local jurisdiction the offense is either committed or you are going to make the arrest. So this is a very important point here. All of you, this is a very important point, that only under exceptional circumstances you can arrest a woman after sunset and before sunrise, provided you've made a written report and you've obtained the prior permission of the JMIC here. And this JMIC should be a person in whose local jurisdiction either the offense was committed or the arrest is going to be made. Then we come to section 47. 47 is basically talking about the search here. This is the first time we come to the provision of search. And in 47, when you're making the search here, the search is when you are acting under the warrant of arrest. So you have the warrant of arrest and you have to make a search. This is section 47. 48, Pacha, it talks about pursue of offenders into other jurisdiction. Now, this is a very important question for your prelims. It says that a police officer, for the purpose of arresting without warrant any person, he can pursue such person into any place in India. So it's not necessary, let's say that the arrest warrant has been issued at place X, the person has to be arrested at place X only. He can be arrested any place in India. Section 49 talks about the fact that this person arrested, you cannot use more restraint than it is necessary to prevent his escape here. Section 50, direct question for your prelims. Very, very, very important question. It says that if you have arrested a person here, now every police officer, he is going to communicate the grounds of arrest. This is very important. The grounds of arrest under section 50 are to be communicated to the person who's arrested. Then under section 50, subsection 2, if a police officer arrests without warrant any person other than a person accused of a non-bailable offense. That means if this is a bailable offense, you are supposed to inform the person that you are entitled to bail and he may arrange for any kind of sureties on his behalf. So on this point, section 50, please remember this is a direct question for your exam. Under section 50, two things are to be seen. Number one, you have to communicate the grounds of arrest, and secondly, if it is a bailable offense, you have to inform the person that he is entitled to bail and he has to arrange for sureties. Now we come to section 50A, most important provision, direct question for prelims. This is a mandatory provision, bacha. Under section 50A, this was not a part of the original CRPC. It was added by the amendment of 2005. Very important amendment of 2005. Now, obligation of a person making arrest to inform about the arrest to a nominated person. Now, under section 50A, we come to a nominated person here. That who's a nominated person here? Now it says every police officer or any other person making an arrest, what is he going to do? He is going to give the information. Information of what? Information of the arrest to whom? To any of the friends, any relative, bacha, or any nominated person by the arrested person. Okay, so either the friends can be there, relative can be there, or the person nominated by the arrested person. So the police officer is to give the information of the arrest. Then the police officer shall inform the arrested person of his rights. Now, as soon as the arrested person is brought to the police station, the police officer is going to inform the rights that you have a right to inform that you are being arrested to a nominated person. Now, this entry will be made in a book. The entry that you have informed the arrested person of his rights, this entry has to be made in the book. Now, this is a very important point. Every magistrate, it is shall a duty of a magistrate, bacha. Now this particular subsection, it is imposing a duty on the magistrate that when arrested person is produced before him, he has to see whether the person has complied, the police officer has complied with this particular duty or not, whether the entry was made in the register or not. So section 50A is very important. Section 51, direct question, section based question has to be seen. That how are you going to make a search of the arrested person? Very important. Section 51, search. Section 52, the power of seizure to offensive weapons. Now, if when you're making the arrest, if the arrested person is found with any offensive weapons, now what is going to happen? The police officer is going to seize all the offensive weapons if he has in his custody. So section 52 talks about the power to seize the offensive weapons. 51 talks about search of arrested persons here. In 53, we have a medical examination that has to be done at the request of the police officer. Here under section 53, bacha, the medical examination is done at the request of the police officer of the accused. In section 53A, if you look at section 53A, this was added by again the 2005 amendment, which is 2006 actually. Here, what is going to happen if there is a person who is accused of rape? So only in cases of rape, the accused of rape, he will be medically examined under section 53A. In 54, section 54, bacha, the medical examination of the accused takes place as a matter of right here. Now in 54, the accused can themselves, he can ask the police officers to make a examination. So medical examination under section 54 is done as a matter of right by the accused, bacha. In section 53, what is going to happen? This is done by the police officers only. 54A, very important question, prelims question here, identification of the person arrested, bacha. Now what happens whenever a person is arrested or he's being brought before the police officers here. Now the police officers, they can take the permission of the court having jurisdiction here that we want to get identification of the person done. So the identification of the person will be done under section 54A here. But by the 2013 amendment, this particular provision was amended that if the person who's identifying the person arrested, let's say he's mentally or physically disabled, bacha, now this identification is going to take under the supervision of whom? Under the supervision of a judicial magistrate, and this entire process is going to be videographed. So section 54A, it deals with the identification of the person arrested. The identification here, it is going to take place at the behest of the police officer. The order has to be obtained from the court. If the person identifying is physically or mentally disabled, remember, under the supervision of JMIC, identification process, it has to be photographed. Now in section 55, we are talking about a procedure when the police officer deputes a subordinate to arrest without a warrant also. So in such a case, what is going to happen? You can make an order in writing and you can specify that a subordinate can also arrest a person without warrant. 55A is very important. Under section 55A, bacha, this was added by the 2009 amendment. And here, what are we saying? That it is the duty of the person having the custody. The word used is shall here. So it is the duty of the person having the custody of an accused to take reasonable care of the health and the safety of the accused. So this is mandatory here, that you have to take care of the health and safety of the arrested person. Section 56 is saying that when that is a police officer, when he makes an arrest without warrant, now without unnecessary delay, what is he going to do? If the bail is not applicable here, he is going to bring the arrested person before a magistrate having jurisdiction in the case, or even before in charge of a police station. So both the provisions are applicable under section 56 here. So if you arrest a person without warrant, what is going to happen? You need to produce this person before a magistrate. Which magistrate? Having jurisdiction in the particular case, or before a officer in charge of a police station. Section 57 is the most important section. You can expect this in your paper, that a person arrested not to be detained more than 24 hours. So, but this particular section is saying that the police officer who has detained a person in custody without a warrant, the maximum period that you can detain this person is 24 hours. And when you count 24 hours, you are going to exclude the time of travel here. So the time of the time of travel, that is the time of journey from the place of arrest to the magistrate's court, is going to be excluded here. Okay. Now in section 58, we are talking about apprehensions here. So if there is a officer in charge of the police station, he is going to report to the DM in case of any apprehension he has. So they have to be reported to the DM. 59 talks about discharge. So no person, if you've arrested if a person has been arrested by a police officer, he cannot be discharged except on two things. Please remember, one is the bond, then is the bail, and then is the special order of a magistrate. So basically 59 is talking about three provisions: bail, bond, special order of a magistrate. Very important question for your prelims. Please underline. How can you discharge a person? Either on bail, bond, or special order of a magistrate. Now let's say section 60 says that if there is a person who's in a lawful custody and he escapes from the custody, he can be immediately pursued or arrested in any place in India. So if once a person escapes, he can be arrested anywhere in India. And section 60A, it says that the arrest has to be made strictly according to the code of CRPC. No other provision is going to be applicable here. It has to be in regard to CRPC. Chapter 6, Pachar, now it talks about how are you going to compel the appearance. So we have summons first. So when we speak of summons, section 61 is talking about, okay, 1 second, all of you. When we speak of summons, everybody, in summons, what is happening? In summons, who's going to issue the summons? If they are going to be issued always in writing, underline. They have to be in duplicate, underline. It has to be signed by the presiding officer of the court, and it should have the seal of the court. Please remember, writing, duplicate, Presiding officer is going to sign it, and it is going to have the seal also. Now, the summons, bacha, they are given in form number 1. Please write it down. Form number 1, second schedule. First schedule talks about the classification of the offenses under IPC. Second schedule is talking about the forms. So summons are given in form number 1, second schedule. The summons, please remember, writing, duplicate, signed and sealed. How are you going to serve the summons? The summons, they are either served by a police officer or they can be served by any other officer here. Now the summons are to be served personally. Okay, so you're going to serve the summon personally here. And every person on whom the summon is served, please remember, he needs to sign a receipt which is given at the back of the summon. So at the back of the summon, there is a receipt. You need to sign that particular receipt there. Now, what is going to be the scenario when the person summoned, he cannot be found? Section 64, very important. Let's say the person summoned, after due diligence also, bacha, you cannot find this particular person. Now, what are you going to do? You are going to leave one of the duplicate with whom? Adult male member. The word used is male member. It is not a female. It is adult male member who is residing with him. And when you leave this summon, you have to get a receipt countersigned on the duplicate. There is a receipt. You need to get it countersigned by the person to whom you have delivered the summon. So the summons, the duplicate will be given to whom? Adult male member. If the person to whom summons have been issued, you cannot find them. And the explanation is very important again. Is servant a member of the family within the meaning of section 64? The answer is no. Section 64 makes it clear that a servant is not a member of the family. Now, when you come to section 65, all of you, section 65 is talking about a procedure when the service of the summon cannot be effectuated. What are you going to do now? You have tried under section 62, 63, 64. Now, what are you going to do? Now, the serving officer, please remember, he is going to, the word used is shall, he is going to affix one of the duplicate where? To the conspicuous part of the house where this person resides, and thereupon the court, after making the inquiry, the court is either going to declare two things: that we have delivered the summons, that means the summons have been duly served, or we can order the fresh service of the summons also. So if the person is not found, if you've made all the efforts, you are going to fix one of the duplicate at his house now where he is residing. And after making the inquiry, the court is going to do two things. Either the court is going to say that the summons have been duly served, or the court is going to assume that fresh service is going to be made. Now, 66, very important question for your prelims. If you want to issue summons to a person who's a government servant, to whom are you going to give it? You are going to give it to the head of the office here. Please remember, head of the office under section 66. Now, the person to whom the head of the office where this is going to be delivered, this person is going to endorse it under his signatures. When he signs this signature shall be evidence of due service here. Under section 66, subsection 2, please remember, the signature is going to be shall be evidence that yes, we have served the summons here. Section 67, bacha, talks about when you have to serve summons outside the local limits of the jurisdiction of the court. Now you are going to send it in duplicate to a magistrate within whose jurisdiction either the person resides or where it has to be served. 68 says that proof of service in such cases when the serving officer is not present. Let's say summons have been issued outside the local jurisdiction. Okay, and the officer who has issued the summons, he is not available at the time of the trial. Now what is going to happen? He is going to issue an affidavit. In this affidavit, he is going to write down that yes, all the the process was followed by me properly, and this affidavit here is going to be attached to the duplicate of the summons and it will be returned to the court here. 69, very important, direct question for your prelims: service of summons on witnesses. Now here we are talking about when the summons can be issued to the witness by post. Very important question, bacha. Now section 69 says if there is a court that is issuing a summon to a witness may, in addition to and simultaneously. Two things are there. In addition, in simultaneously, what are you going to do? One, you've issued the copy of summons. Another, you can direct a copy of summons to be served by a registered post also. And where are you going to send it? You are going to send it where the person either resides or he carries on the business personally or works for gain. Please remember, section 69 here, it is dealing with whom? It is dealing with the witnesses, when the witnesses are going to be given summons by post. So section 61 to 69 deals with your summons. We come to section 70 now. The second part here is dealing with the warrant. Now, the form number 2 in the second schedule. So the first form number 1 deals with summons, form number 2 deals with your warrants here. Now section 70 says that a very, very, very important question, that every form of warrant of arrest, bacha, it has to be in writing, it has to be signed, and it has to bear the seal of the court. Very important. Signed, writing, and it is going to have the seal of the court. And this is the most important question here. Till what time is the warrant going to remain in force? Very important. Till the time it is not cancelled by the court which has issued it, or it has not been executed. So the two things only. It either has to be cancelled by the court that has issued it, or it has to be executed. Only then, till that particular point, the warrant here is going to remain in force here. Then section 72 talks about to whom the warrants may be directed. Please remember that a warrant of arrest is always ordinarily directed to a police officer here. Okay. But section 73, it talks about warrant may be directed to any person. Now 73 is your prelims question. It says that where the CGM or the JMIC, where they feel that a warrant of arrest within his local jurisdiction is necessary for the arrest of an escaped convict, there is a proclaimed offender, bacha, or there is a person who is accused of a non-bailable offense and is awaiting arrest. Now this can be issued to whom? Any other person. Section 73 deals with any other person. 74 deals with specifically a police officer. Don't get confused. 72 talks about to whom they are going to be directed. 73 talks about the person here, that is your any other person. We studied about section 38. Please remember, section 73 has to be read with section 38, because in 38 we were talking about aiding in execution of the warrant of arrest when it is given to any other person here. Okay. So section 74 talks about your police officer. 75 is telling you that when a police officer or any other person, bacha, they are executing the warrant of arrest, they have to do something. What are they going to do? They are going to notify the substance. Firstly, they're going to tell them that this is the substance why you're being arrested, and then you have to show the warrant also. So please underline, substance plus show. Both the things have to be done here. Now section 76 is telling you that a person arrested, very important question for your prelims, bacha. Expect a question on this particular section. Section 76 tells you that if a police officer or any other person, they have arrested you, without unnecessary delay, you have to bring the person before the court. So you have to produce the person before the court. And again, the same thing, you can exceed 24 hours. When are you going to exclude the 24 hours? When the time of journey is there. So normal circumstances say that you cannot exceed 24 hours. But when you calculating 24 hours, remember the travel of journey will always be excluded. Okay. Section 77, section based question, very important. Where can the warrant be executed? Warrant of arrest, bacha, it may be executed at any place in India. It can be any place in India. It's not necessary that it has to be at the place where the warrant of arrest is issued. It can be executed any place. And before I forget, in section 76, bacha, you have to read this particular section with section 57, also with section 167. So section 57 read with section 167. Now section 78 talks about warrant when it is forwarded for execution outside the jurisdiction. 79 talks about warrant directed to a police officer for execution outside the jurisdiction. On this point, please come to the most important point here is section 81. All of you come to section 81. Now in 81, what is happening, bacha? Procedure by a magistrate before whom such person arrested is brought. Now let's suppose there is an executive magistrate, okay, or there is a DSP or commissioner of police. If a person arrested, he appears to be the person intended by the court which issued the warrant. Now these people, this particular person will be brought before the EM, the DSP or the CP. Now if these people find, now this is important, underline, that the offense is bailable. Now what is going to happen if the offense is bailable? Who's going to give you the bail? Such person is ready and willing to the satisfaction of such magistrate, DSP or commissioner. Now the bail will be given. But if the offense is non-bailable, this is your prelims question. It shall be lawful for whom? Now we have CGM. Now we have session judge of the district in whom the arrest is made on the consideration of the information and the documents referred under section 78 subsection 2 to release such person on bail. So if the person is arrested outside the local jurisdiction, correct, where the warrant of arrest was to be executed, pacha, remember it is EM, DSP or the commissioner. If this offense is bailable, they are going to give you the bail. If the offense is non-bailable, now we have CGM or session judge who can give the bail, considering what? It has to be considered, the information which is presented before you under section 437 of CRPC. This is a very, very, very important question for your prelims here. Now we come to section 82. 82 talks about the proclamation of for the person who's absconding. Direct question is important. What is 82 telling you? It is saying that if the court has reason to believe, now the court here has reason to believe, it does not matter whether the evidence has been taken or not. You know that against the person whose the warrant has been issued, this person is either absconding or bacha he's concealing himself, and the warrant cannot be executed. Now what are you going to do? The court is going to publish a written proclamation. Written proclamation for a time period here is not less than 30 days. This is very important. Please remember, we don't, this is not relevant here whether the evidence was taken or not. That is not important. What is important here? That warrant of arrest was issued, this person is absconding or this person is concealing himself. Now written proclamation time period is going to be less than 30 days. Prelims question. Now comes the most important part of this particular section. But this proclamation shall be published. How? Very important. Please remember, clause 1, 2 and 3, that is A, B and C, they're very, 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 very important. It says it has to be publicly read. Mandatory provision. You publicly read it. Read it where? Some conspicuous place of the house. For example, let's say X is a person where against whom the proclamation is issued. Now this proclamation will be publicly read in the conspicuous part of the house or of the town where this person is residing. Then it is going to be affixed also. You're going to fix this at the conspicuous part of the house. So you're going to publicly read it out. You're going to fix it to the conspicuous part of the house. And this copy is also going to be affixed at the conspicuous part of the house. Bacha, all these three clauses are mandatory. They are conjunctive, meaning thereby they are to be fulfilled together. Publicly read plus conspicuous part of the house plus copy will be fixed at the conspicuous part of the courthouse. Mandatory. So the word is shall. The court may. Now this is a directory provision, not mandatory. If the court thinks, now this copy of proclamation can be published in a daily newspaper also. At times, this question is asked in the paper whether this is mandatory publishing in the daily newspaper. The answer is no. What is mandatory? Publicly reading is important. Affixing it at the house is important. What is other thing? You fix it at the conspicuous part of the courthouse. This is mandatory. What is not mandatory? Reading it in the public in the daily newspaper. You do not have to publish it in the daily newspaper. This is not mandatory. And what kind of evidence is this going to be? This is going to be a conclusive evidence that yes, on such and such date, this proclamation was issued here. Now, all of you come to section 83. Now, 83 talks about the attachment of the property. In 83, what is happening? The property will be attached. Whose property will be attached? The court that is issuing the proclamation under section 82, if they have reasons to believe, when? After issuance of the proclamation. So, number one, proclamation will be issued first, property will be attached later on. What kind of property can be attached? Any kind of property, movable or immovable. When you know that this particular person, so there's a ground, if the court thinks that this person against whom the proclamation is issued, bacha, he is about to dispose of the whole part of his property or is about to remove any part of the property, now what is going to happen? The court may order the attachment simultaneously with the proclamation. General rule is what? Proclamation comes first, after that you have attachment. But if the court is satisfied that either the person here is going to dispose of his property or is going to move his property, now the court may order simultaneously order of attachment with the issue of proclamation. This is a very important question for your exam. Very, very important. Such order, bacha, such order here, it has to be informed to the DM. If you've made any order, the DM under whose district this property is situated, he needs to be informed about this. Section 83 subsection 3, bacha, it is talking about your movable property. Section 83, 84, 83 subsection 4 is talking about your immovable property here. And remember, the powers and the duties of the receiver, if he's appointed, he's going to have the same powers which are given under a receiver to under CPC. Now come to section 84, all of you. 84 is talking about the claims and objections to your attachment. Now let's say if you have any claim or you want to make any objection to this attachment, you can make it. Of course, you can do it within 6 months. This is important. 6 months from the date of attachment, you please make your claim or any objection. But here, it is by a person other than a proclaimed offender. So here, we are talking about, he can be any claimant here. He can be any objector, but not the proclaimed offender. So proclaimed offender is the one whose property is being attached. But if there is any other person who has any claim or objection to this attachment, please raise your objection within 6 months. But remember one thing in this particular section, that in section 84, any person whose claim has been disallowed in whole or in part under subsection 1, within a period of 1 year, you can institute a suit also. For example, you file, you raise an objection within 6 months from the date of attachment. Now what happens? Your claim has been dismissed. Now you have a period of 1 year. Within period of 1 year from the date of order, you can institute a civil suit also. And whatever is going to be the result of the order, it is going to be conclusive. Okay. Now in section 85, we are talking about release, sale, or restoration of the attached property. Now you have attached the property of the proclaimed offender. Now let's say the proclaimed offender, he comes within time. If let's say the time period is 30 days, within 30 days, the person comes, now the court is going to release the property. The word used is shall. Now the property will be attached. But let's say the property, this proclaimed offender, bacha, he does not appear within the time which is specified. Now what is going to happen? This property is going to be at the disposal of the state government. Now this is up to the state government how they want to deal with it. But they're not going to sell the property till the period of 6 months. But If this is a perishable property, then it can be sold off. So if it is subject to speedy and natural decay, now what is going to happen? It is going to be sold. And now, if within 2 years from the date of attachment, the person whose property is or is as disposal of the state government, now he comes before the court, now the property can be discharged here. Okay. If you want to appeal from any order, either rejecting the application, how are you going to do it? You are going to appeal to whom? To the court to which the appeal ordinarily lie, from the sentences of the first mentioned court here. So here, please remember, you have to file, if you want to file an appeal, you can go in for appeal also. In this regard, please remember section 84 is very important, and 83, 82, they are very, very, very important. We come to section 87. Now, but the 87, the most important section here, can warrant be issued in lieu or in addition to summons? This is the question here. The court may. 87 says the court may, if you are empowered to issue summons after recording reasons in writing. Yes, this is important. You record the reasons in writing, now you can issue a warrant of arrest also. So if the question is, can warrant of arrest be issued in lieu of summons? Yes, it can be done, but the reasons has to be recorded in writing. Now, the word which is used in this particular section is any person, appearance of any person. Bacha, most important point here, any person here, it can be an accused also, it can be a witness also, not necessarily an accused or a witness. Now, when are you going to issue warrants in lieu of or in addition to summons? If either before the issuance of summons or after issuance, but before the time fixed for his appearance, now the court has reasons to believe that this particular man, either he's absconding or he's not going to obey the summons. Or if at such time he fails to appear and the summons is proved to have been duly served in time to admit of his appearance in accordance therewith, and there is no reasonable excuse offered for such failure. Now the court is going to do what? Now the court here is going to issue warrant in lieu of summons here. On this point, bacha, section 88 is your prelims question. Section based question is asked that where is the power to take bond for appearance given? It is section 88. Now, if the bond has been given by you and this person does not appear, now this person can be arrested also. So warrant can be issued where this person can be arrested under section 89 here. Okay. Now we come to the next chapter, that is chapter 7 here, and we move on to section 91. 91 is very important, and it is talking about summons to produce a document or a thing. So far we discussed about summons which are issued to a accused, summons which are issued to a witness also under section 69 by registered post. Now we are talking about summons that are being issued to produce a document or a thing. Now, this is a discretionary power of the court, bacha, that whenever any court or any officer in police, officer in charge of a police station, so underline court, or it can be officer in charge of police station, and they know and they feel that any document is necessary or any other thing is necessary for any stage. It can be investigation, it can be inquiry, it can be trial also. Now the court here can issue summons here. Either the summons will be issued or a written order is going to be issued to the person in whose possession or power such document or thing is. The word person here, remember, the word person here does not include an accused here. We are not talking about accused here. Okay, so you cannot issue summons to an accused under section 91. Any person required under this section merely to produce the document or a thing shall be deemed to have complied with the requisition if he causes such document or thing to be produced instead of attending personally to produce the same. So if even if this person delivers the document or a thing, it will be presumed that yes, this person has delivered the document. Under this section, this is very important, Bacha. This is your prelims question. Does section 95 affect these two provisions? No, nothing in this section shall deem to affect. Please underline, this is very important. Section 123 and 124 of the Indian Evidence Act or the Bankers Book Evidence Act 1891. This is your very, very, very important prelims question here. Very important. 123, 124 is not getting affected here. And then this section is not going to apply to a letter, to a postcard, to a telegram or other document which is in the custody of a postal or a telegraph authority. Now, why is this proviso here? This proviso is here because section 92 is specifically dealing with the procedure as to the letters and the telegram. Now it says, if any document, you have any parcel, you have anything which is in the custody of a postal or a telegraph authority, in the opinion of, please underline, prelims question here, bacha, DM, CGM, or the Court of Session or High Court. So all these four are included here. DM, CGM, Court of Session or High Court. It is wanted for any purpose. Now these magistrates or the court, what are they going to do? They are going to issue, and you have to deliver this document, parcel or thing to the person as the magistrate or the court directs here. So section 92 is specifically talking about the postal or the telegraph authority here. Now let's say this document, this parcel, this thing that we are talking about, it is in the opinion of any magistrate. Now here, executive or judicial or CP, that is the Commissioner of Police, or the DSP. Now they want that such thing, they need it for any such purpose. Now what is going to happen? He may require the postal or the telegraph authority that you have to deliver this pending the order of this, pending the order of district magistrate, CGM, or the court which is given under subsection 1, that is your Court of Session or High Court here. So section 2, it is talking about 4 kind of people who have, in whose opinion, the procedure as to the letter and telegraph is going to matter. That is DM, CGM, Session or High Court. Now we come to section 93. 93, it is talking about when the search warrants may be issued. Now when can the search warrant be issued? 93 says, bacha, that where the court has reason to believe that a person to whom the summon order has been issued under section 91 or 92, and this person is not going to produce this document or a thing. Now you know for sure that you have a reason to believe. Who? The court. They have a reason to believe that this person here, he is not going to produce the document or thing, or the document or a thing, we know it is in the possession of any other person now, that the court, and the court considers that it will be served by general search or inspection. Now what are you going to do? You are going to issue a search warrant and you're going to search this place. Now the court may, if it thinks fit, specify in the warrant that the particular place or a part thereof to which only this particular search or inspection shall extend, and the court is going to say, okay, you can only search this specific area or you can search the entire area. This is up to the court here. Nothing in this section shall authorize any magistrate other than a DM or a CGM. Very, very, very important question here. If you want to search for a document, a parcel or a thing which is in the custody of the postal or a telegraph authority, only 2 people have the authority to make the search there, which is a DM or a CGM. Now we come to section 94. But remember one thing. If there is any other person, let's say judicial magistrate first class, he makes a search in the case of the postal or a telegraph authority, now this search here, it is going to be void. You cannot do it. It is just the DM or the CGM who have the power here. Now section 94, bacha, on this point, it is talking about search of place suspected to contain your any kind of a forged document, or it is having any stolen property. Again, here what is happening, if the district magistrate, SDM, or a JMIC, if they receive information, okay, and receiving information, they know that this place has any kind of an objectionable material. Now they're going to take into custody. They're going to make a search of this particular place here. On this point, under section 94 subsection 2, you have to read these objectionable articles, that what are the objectionable articles which are mentioned in section 94 subsection 2. Now, section 95 is again very, very, very important. And why is it important? Because it is dealing with the power to declare certain publications forfeited and to issue the search warrant. Here, let's say there is a newspaper, there is a book, or there is any document, whichever is printed, and this appears to the state government. It is not appearing to any other authority. It is only appearing to the state government here. Appearing what? That this is going to be, that this publication here is punishable under section 124A, 153, 153B, 292, 293, or 295A. Please underline these particular sections. These sections are very important itself. Now, in section 95, the state government says that there are specific grounds here. These are the grounds. These are the sections which are going to come into power. Now the state government is going to issue a notification, and they are going to forfeit all these books, all these copies, everything will be forfeited here. Now, once you forfeit, somebody has to forfeit. Who's going to be that officer? This officer should be any police officer not below the rank of sub-inspector. Okay, he's going to go, he's going to make the search also. Now, once you have, forfeited, section 95 subsection 3 says that this particular order, it will not be called in question in any other court except in section 96. So the power of forfeiture given in section 95, bacha, the remedy lies in section 96. Section 96 is the remedy dealing section to section 95, and it is saying who has the power? Only the High Court has the power. Okay, please remember, you can only apply to the High Court. Time period is within 2 months. So within 2 months from the date of the publication of the official gazette, within that period, apply to the High Court. Now what is going to happen? A bench will be, the High Court is going to constitute a bench to deal with the matter. It's going to have 3 or more judges. Okay, so this is section 96. The remedy, the power of forfeiture given in section 95, the remedy is given in section 96 here. Now, when you come to section 95, this is the habeas corpus which has been, incorporated in CRPC. So section 97 says what is going to be the search for the persons wrongfully confined here. Very important question. Section 97, direct question here, bacha. Any DM, it can be SDM also, it can be JMIC also, when they have reason to believe. What is the reason to believe? That any person has been confined. Now what are they going to do? They are going to issue a search warrant, and immediately they are going to go search that place, and they're going to release that person from there if any person is wrongfully confined there. Section 97, bacha, it is to be read with section 340 of IPC, which deals with wrongful confinement, read with section 345 of IPC, where the writ of habeas corpus is issued. Even then the person is not, he's not being released here. So 97, it incorporates the writ of habeas corpus in CRPC. We have 3 people who have the power: DM, SDM, JMIC. The person can be any person. This is gender neutral, not gender specific. Gender neutral: man, women, boys, girls, kids, old person, anybody. But at the same time, section 98 is a specific section, and it talks about the power to compel restoration of abducted females. Now this is important, bacha. There is a complaint which is made on oath. So the complaint has to be made on oath. What is the complaint about? That the abduction has taken place, unlawful detention of women has taken place, a female child has taken place who's below the age of 18, and now the detention or the abduction here is for unlawful purpose. Again, people who have the power remain the same: DM, SDM or JMIC. They can make a order and they're going to immediately issue that we need to immediately release this particular women here. So 97 talks about any other person, but it can be any person. 98 is a specific section talking about only females here. In 97, no oath is required. In 98, oath is to be made. Okay, the case has to be related to a women here. And on this point, all of you come to section 100 quickly. In section 100, we are talking about persons in charge of closed place to, allow search. How are you going to make a search of this particular point? Now, when we speak of search under section 100 here, Bacha, please remember on this point, the most important point is subsection 4 here. Subsection 4 says that whenever you're making a search under this chapter, the officer or any other person shall call upon 2 or more independent and respectable inhabitants of the locality. So he's going to call 2 or more independent, respectable person, and he's going to say that we are going to make a search. Okay. Now the search is going to be made in their presence, and the whatever list of things is seized in this particular search, they're going to prepare a list who the person who's making the search. Now every person, every witness here is going to sign this. Okay, though these people are not required to become a part of a witness, they're not going to be a witness of the police officers here, they are merely going to be a witness of the search here. Okay, this is very, very, very important, bacha. You need 2 or more independent, respectable inhabitants, number 1. Number 2, this, whatever search is going to take place, it will be taken in their presence. Whatever list is seized, whatever items you seize, the list will be prepared, it will be signed by the police officer, countersigned by the witness. Okay, then let's say you come to section 100, come to subsection 8 here. Any person who without reasonable cause, now you don't have a reasonable cause, you refuse, you neglect to attend and witness a search. Now you refuse, you say no, I do not want to be a part of this search. Now you have committed an offense under section 187 of the IPC. This is your prelims question again. So if a person refuses or neglects to basically attend this particular search, now it is going to be an offense under section 187. Okay, moving on. Let's come to section 102. But the section 102, it is dealing with the power of seizure. Please write down power of seizure. Okay. 102, dealing with the power of seizure. Very important question. 103 says that the magistrate is going to direct that the search is going to take place in his presence. Now, in 103, please highlight, this is very important. The magistrate can direct that a search is going to take place in his presence here. Okay, section 104 bacha talks about impounding of the document. Okay, so if the court wants to impound any document, it's going to be under section 104 here. On this note, we end today's session. All those students who have any queries, please, I'll address all your queries here in the chat box. If you have any query, please write down in the chat box. I hope this particular part till section 104 is clear to everybody. Anyone with a doubt? All right. Then thank you so much, everyone. I'm going to see you guys tomorrow and we'll complete the rest of the sections tomorrow. Thank you so much.